In the case of Sutton versus United Airlines, the petitioners were Karen Sutton and her sister Kimberly Hinton. They were represented by Mr. Van Aaron Hughes, and the respondent, United Airlines, was represented by Mr. Roy Englert. The Sutton twins had a lifelong goal to fly for a major air carrier, although they suffered from severe myopia. The two sisters had 2200 vision in their right eye and 2400 in the left. What does this mean? This means that what an average person could see from 200 feet away, the twins could only see from as far as 20 feet away. This problem could be corrected with eyeglasses or contacts, allowing them to see as well as someone with 20/20 vision. The twins were rejected from United Airlines after being told that the company had a minimum requirement of 2100 vision when uncorrected. The Sutton twins brought suit against United Airlines. They claimed the airline was violating the Americans with Disabilities Act of 1990 by discriminating against them. The twins needed to prove that they were in fact disabled as defined under the Act. The Americans with Disabilities Act of 1990 defines a disability as a physical or mental impairment that substantially limits a major life activity, or as being regarded as having such an impairment. The district court dismissed the case, stating that the twins did not meet the criteria to be defined as disabled. They did not meet either of the two definitions because they could function at 20/20 vision with corrective measures. When the twins got to the Supreme Court, they had amended their complaint. They added that the district court had been wrong to dismiss their case because it did not follow the guidelines of the EEOC. The EEOC is the Equal Employment Opportunities Commission, which was created after the passage of the Americans with Disabilities Act of 1990. The Commission's guidelines state that when determining whether or not a person is disabled, you should not take corrective measures into account.
The Supreme Court agreed with the lower court's ruling that the Sutton twins did not meet the requirements to be considered disabled under either of the two definitions in a 7-2 ruling. The justices ruled that the Sutton twins and the EEOC were both wrong in their interpretation of, quote, substantially limits. They said that the phrase involves consideration for the present level of functioning, not a future or hypothetical impairment. Since the twins do wear glasses, which completely corrects their vision, they do not qualify as disabled under the ADA. They also said that since the twins' vision only prohibited them from being global airline pilots, not from many of the other jobs in the aviation industry, the myopia did not qualify as, quote, substantially limiting, and thus did not qualify the twins as being disabled. The Sutton case, in conjunction with the Toyota v. Williams case, has already brought about an amended version of the Americans with Disabilities Act and was passed in 2008. Although the Court of Appeals ruled in 2009 that the changes in the amended Act did not apply retroactively and so they did not reverse the decision in the Sutton case, if it was tried today, it would have a very different outcome. What the amended Act did was it clarified and broadened the definition of disability, as well as stating that corrective measures should not be looked at when deciding whether a person is disabled. The amended Act includes some of the following as examples of, quote, major life activities: caring for oneself, seeing, hearing, eating, walking, standing, and many more. It also lists major bodily functions which should be considered: normal cell growth, respiratory, circulatory, and reproductive functions, as well as many more. The amended Act has taken a substantial burden off the disabled. It has made it easier for courts to rule on whether a disabled person is being discriminated against, rather than focusing on whether the person exactly meets all the necessary criteria to be labeled as disabled. We think that the court did make the right decision in the Sutton case at the time, given the language of the 1990 Disabilities Act. But we also think it was a good decision to broaden and provide more certainty to the definition of disabled in the amended Act.